everyone. My name is Pranav, and in this video I'm going to talk about feminist legal theory. So the feminist legal theory has been developed in 1960s and 70s and has its roots in the women's movement. And in its early stages, the feminist inquiry was into the nature of law occurred as an offshoot of the critical legal studies, which we'll see in next sessions. And to this extent, it was also concerned with providing a basic critique of the inherent logic of the law. The interdeterminacy and manipulability of doctrine and the role of law, legitimating particular social relations, the illegitimate hierarchies created by laws and legal institutions, all of them are on the point of feminist legal theories. So let us discuss, because in India feminist legal theory is a bit of lacking in its application and has been misconceived by various people. So it is in this light, it is very important to understand the methodology of feminist legal theory. So there are three very important features characterizing the feminist investigation into the nature of law. So the very first is, it asks about the women question, that is determining and recognizing the experience of women in relation to the law. Now, for Katie Bartlett, one of the very famous proponent of feminist legal theory, for Katie Bartlett, the essential women question is how the law fails to take into account the experiences and values that seem more typical of women than men. Now, for whatever reason, or how existing legal standards and concepts might disadvantage women. The second prong would be feminist practical reasoning. Now, feminist practical reasoning employs a mode of reasoning arising from above context that I said just, which appreciates the differences between persons and values the experience of the unempowered. And the third very important prong of feminist thinking is consciousness raising individual awareness of the collective experience of women through a sharing of experiences. Now, what does it focuses upon? Feminist legal theory focuses upon various questions, and one very famous person was Heather Wishik, Wishik, Heather Wishik. Heather Wishik told that the feminist inquiry into law can be seen as posing 7 particular questions. The first question would be, what have been and what are now all women's experience of the life situation addressed by the doctrine, process, or area of law under examination? The second question would be, what assumptions, descriptions, assertions, or definition of those experiences, male, female, ostensibly gender neutral, does the law make in this area? So in the context of the second question, I would like to raise certain point that if you have seen in the previous session, whenever I talked about the concerned legal philosopher and I have quoted them, and whenever I quoted them, I have recalled them men as men, as if they haven't considered women at all. So Vishik raises this very important question in their second question. What assumptions, descriptions, assertions, or definitions of experiences does the law make in this area? Now, third very important point would be, or the question would be, what is the area of mismatch, distortion, or denial created by the differences between women's life experiences and the law's assumption or imposed structure? So, in this question, you would see a very important point that if there is this narrative, and in this narrative, there can be two things. The first thing, the law's assumption in this narrative. Suppose marital rape. Now, in marital rape, there are two assumptions. First is law's assumption. The law's assumption is this, that marital rape is not rape. But the women's life experience would be that marital rape is definitely the most brutal form of rape. It is only because of law's ignorance this form of discrimination is happening. This form of injustice is happening. So here, a feminist jurist would say that law is propagating injustice. So, like I said, the third question would be, what is the area of mismatch, distortion, or denial created by differences between women's life experiences and the law's assumptions or imposed structures? The fourth question would be, are there any interests which are involved in the third question, which are involved in the law's assumption? If at all there are interests, what patriarchal interests are served by the mismatch? Now, the fifth question would be, what reforms have been proposed in this area of law or women's life question? How will these reforms proposals, if at all adopted, affect women both practically and ideologically? Now, the sixth question would be, in an ideal world, what would this women's life situation look like? And what relation, if at all any, would the law have to this future life situation? And the seventh and the most important question which can anybody ask, how do we get there from here? Now, let us discuss the subject of feminist legal theory. Now, the subjects of feminist legal theory would be scrutiny, scrutiny of various laws, right? By feminist legal theory would bring forth various subjects, and let's say rape within marriage, let's say surrogate motherhood, pregnancy and maternity leave, let's say pornography, let's say different retirement ages or employment issues. So these can be subjects of feminist legal theory. And further to this, other traditionally black letter law subjects have been opened up to enable the specific experiences of women to be taken into account. Now, let's do a case study here. Sabrimala judgment again. Now, there is this DT, and there are subjects of the DT, that is men. Women cannot go there. Why? Because of menstruation. Why? Because menstruation makes women dirty. Now, this notion of thinking menstruation makes women dirty, as per Justice Chandrachud, is exploitative, is discriminatory under Article 17. It propagates untouchability. This is a feminist line of thinking, and it is feminist line of thinking which provided substantive judicial remedy to the women who were affected by the Sabrimala practices. Now, with this, let's come to the feminist approaches of feminist legal theory. The most important would be the identity argument. Now, Catherine McNaughton. Catherine McNaughton has written a paper or a book towards a feminist theory of state, where she where she questions the authority of state and says that law is to be understood as both a symbol and vehicle of male authority and a paradigm of maleness, maintaining male domination, a particularly potent source and badge of legitimacy, a side and a clock of force. Ellen Finlay would argue that law is a patriarchal form of reasoning. So, what is this identity argument? One view within feminist legal theory is that there is no significant difference between men and women. If anything, the only real difference is that of inequality, right? In all patriarchal societies, men dominate the lives of women. All structures of such societies, including legal system, are set up to control, oppress, and to facilitate the exploitation of women by men. Now, it is only because of this inequality with men. The different values which women appear to hold or exhibit are simply their reaction to a male dominated situation and are not really an expression of anything intrinsically female. What is intrinsically female? Right? Question this. Now, feminist responses to this situation include the appeal to formal equality, which tries to minimize the difference by invoking the principles that individuals who are alike should be treated alike. In other words, that women and men should be treated on exactly on same terms. Substantive equality, on the other hand, argues that because of the inequality already at work within the society, equal treatment will still result in unequal outcomes. So, what is required then is an equality which is based on the consequences of rules rather than the equality of the rules themselves. So, focus on the results. Now, the law is essentially a male instrument if you see closely, and this gives it an inherent masculinity which cannot be changed simply by increasing women's entry into the structure of the legal system or by incorporating female values in its rules or processes. Similarly, it is futile to try and use legislation or litigation to try and improve the status of women because of its male character. Imagine Chandrachud is deciding female question. The law will simply produce male centered outcomes and reproduce male dominated relations. The apparent neutrality of law and equality of all persons before it, thus a myth and a fantasy promoted by a state which, by appearing to be a liberal, promotes a false consciousness amongst women which convinces them that they are actually free and when they are not. Now, one appropriate preoccupation of feminist legal theorists of identity school would be consciousness raising, which will lead women everywhere to become more aware of their oppressed conditions and the need to transform patriarchal society. Now, once this awareness occurs, then what? Then there may be a rise a real female consciousness which will look beyond state, beyond law for formal equality, no, so for substantive equality, pardon, which will lead to a radical and fundamental restructuring and reorienting of society's basic structure, including legal system and law. Now, in the next session, I will discuss about difference arguments. Till then, thank you.